Hello everyone. For today's Murphy Law Monday, I want to touch on a hot topic that's been coming through my office a lot, and it's modifications in the state of Maryland and the District of Columbia. Now, what is a modification? A modification basically is a request of the court to change an existing order, either because there has been some type of material change in the lives of the parties, or there's been a material change in the life of the child. And I wanted to touch on this topic because people think that modifications can just be filed willy-nilly. I didn't agree with what the judge said. Can I file a modification? No. A modification has very specific requirements. You have to think about it like the judge went through the entire process, or you and the other party came to a whole agreement, and now you want the judge to undo what they've already done. And you have to think that in order for them to have a basis to do that, there has to be a real reason. And it can't just be, we don't get along. It has to be something that affects the child and has essentially affected the ability to co-parent the child, such that now the court needs to step in and change what they've already done. And I will say that the burden to prove the basis for a modification is very high. You're definitely going to need an attorney. You're definitely going to need proof of actions. You're definitely going to need proof of a change, and not just any change, a material change, a change like moving from North Carolina to back to Maryland, a change like the minor child is now 16 and he wants to live with his dad, a change like the child has a voice and wants to be heard in court, whereas when we first entered this, he was 3 years old. Or a change relating to child support that says, oh, when we entered this, I was making $60,000 a year. Now I make 3 times that, or now dad makes 3 times that. And now we want the child support to be modified accordingly. Those are material changes. Material changes are not, again, that you guys do not agree with the order or that you specifically don't agree with the outcome of the case. You can't file a modification right after the case happens. I would say give it some time. Give it a chance to flourish and a chance to grow into something that you can become accustomed to. Document instances where you and the other party are not agreeing, or that it's affecting the child, absences from school, tardies from school, different things like that again affect the child, are things that the court want to hear and see during a modification case. If you're in need of legal services in the state of Maryland or in the District of Columbia, please give my office a call, 240-493-9116 and www.amurphylegal.com. Thank you.